workforce development on a local, regional, and statewide basis. Ms. Harris, do we have any comments from the public?
No, sir.
Do we have any comments from the audience?
What section of the manual is this?
This is the very first section.
What title? So like you got policy 1, 2, and 3. Ms. Bro, what section would this be in the manual? Like in the old manual, if you go to it, there's an introduction where this information will be held. So is this part of the introduction to the new manual? What is this?
This is gonna be the introduction of the new manual.
So
What's in
there's a
place of it?
section in this new manual called introduction, like, cause these are just general policies, I don't understand how as a committee, you're gonna vote on these and we don't know what they're related to in the new manual. I understand you're trying to revise the manual, but how do all of these connect to each other? What is what section of the manual is this going to be?
It'll be in the new manual on the 00, on the guidance of LSBA.
What is 00? What's the header for 00?
Policy, definition.
But disclaimer is its own, see, that's why it's confusing. Disclaimer is its own policy that you're talking about. Number 2 is its own policy that you're talking about. Number 3 is its own policy that you're talking about. How are these grouped together as 1 through 8? What section of the new document is this gonna be? Ms. Bro, Chair,
On the
please.
guidance of LSBA, this is the process we're following. You can email LSBA and ask for a rationale why they guided us
But
this way.
you're here today to do the business of the people, and we're asking you who are going to be tasked with voting to say that you agree with this. What's your rationale for giving your vote to this information? And that's why I'm asking the question. What's your rationale to group these together? What are they gonna be grouped as? You're the voting members, you're the people we elected. We didn't elect LSBA.
Thank you.
They fall under the board policy, at the first, we open first document as the board, the board's authority, just falls
Yeah.
under that first.
Thank you, Ms. Walker. Policy 04, addition, repeal, or amendment of a policy shall require a majority vote of the members present and voting at a duly noticed meeting of the board. No policy shall be considered for final action by the board at the same meeting at which it is originally proposed, except upon a unanimous vote of the members of the board present and voting. The superintendent or their designee shall periodically review the district policy manual and annually review the actions of or guidance from the U.S. Department of Education, Louisiana Legislature, Bessie, and LSBA to determine policy recommendations. At the discretion of the president, proposed policy recommendations shall be submitted to the policy committee for action as provided for in policy 104. Ms. Harris, do we have any comments from the online?
Yes, sir. Roniqua Watkins, why can't you follow the current policies as written? No justification has been given for limiting the voice of the people. I have complained about this numerous of times. How about you hold a committee meeting to craft the requested changes? Require committees to introduce the changes in a board meeting. Give the public time to understand how the changes impact all stakeholders. Then vote on it in a future meeting. No policy changes are required. Just do what you have documented and the system will work just fine.
Do we have any comments from the public?
Yes.
Oh, I'm sorry. Don't they only get one comment? She did it online, so you
No.
can comment again.
There's no policy for that currently within Bow Lucy City School System.
Do we know?
That it's not documented. So yes, I would like to expound on that, in that the current policy in school board policy says that the language is clear, introduced at one meeting and officially adopted at the next. Whereas this is unclear in that it simply says, final action will not be taken at the same meeting. The current policy has specific procedural action to take. Introduce at one meeting, and then you officially adopt at the next. So why does this new language seem clearer to you, to the public, and how to interact with you as the board versus the language that you already have adopted as policy? Why is this new language better? Simply because LSBA told you that?
Thank you. Thank you very much. Policy 505. A policy may be suspended upon a majority vote of the board. A policy suspension shall not exceed 1 calendar year, after which the policy becomes effective again, unless otherwise repealed or revised. The same policy shall not be subject to a subsequent suspension within 60 days of the expiration of a previous suspension. No policy mandated by federal or state law or rule may be suspended. Ms. Harris, do we have any comments from online?
No, sir.
Do we have any comments from the public?
Okay, so there is no suspension policy, well, yes, it is, it's a policy. The current policy only requires you to temporarily suspend. So it will require you to make a motion. Right now, if you do what you have right here, as soon as you say something is in effect, it's just done for a year. There's no, you'd have to know the policy to come back after a calendar year. Why must it be for 1 year or not to exceed 1 year? Why can't you take that out and put in that you are required to make a motion that identifies the time frame for which you're asking for the suspension, and then act on the action? Yeah, that will require you to state and document within the record the rule and policy that you're suspending, and then you'd have to make a second motion to identify the action that you want to take. So then by record keeping, you would clearly have defined this time frame in there that you could go back to and look at. The way this is written, you'll make it one time, and we, it's just gonna be there for a year. Thank you.
Thank you. Policy 06. The policy shall be posted on the board's website and shall be available for review in the board's office. The superintendent or designee shall ensure employees, students, and parents are properly notified of the revision, repeal, and adoption of policies. Ms. Harris, do we have any comments from online?
Yes, sir. An unanimous response. Policy exists with the same language. What is the rationale for this?
Do we have any comments from the public?
What's the rationale? Dissemination is already included in the current policy, and that's why it's kind of hard to follow these, because those are grouped in a way in which a person can see why this language is important. But right now, this is just blind language, so it's kind of hard to understand what part of the old language is. So under agenda preparation and dissemination, in the previous manual file BCBD, it's very specific. It tells you that an agenda has to be in by a certain amount of time. Is this the only language you're going to carry forward? When are you going to get to the other parts of the language required to disseminate information? Telling the public when it's got to be to them. Telling them when it needs to be posted, when it needs to be submitted. All of that's currently in here, and this is just a brief couple lines that doesn't even cover what we already have.
Thank you. Policy 07. The superintendent shall formulate administrative regulations to provide directives relative to the superintendent's authority provided in state law or rule. In addition, the superintendent may formulate regulations to further define board policy to ensure all personnel and students of the system adhere to and comply with requirements set by board policy, and provide directives on issues that where there is an absence of board policy or controlling federal or state law, rule, or regulation. Ms. Harris, do we have any comments online?
Yes, sir. One anonymous. Keep the language in BD that says the superintendent has checks and balances with review by the school board.
Thank you. Do we have any comments from the public?
Yes, I agree with that comment. If you go to BD school board policy, this is already in there. This new language eliminates your ability as the board to have any checks and balances. Whereas before, the superintendent already had this right to formulate administrative regulations, but there was a documented caveat that it was subject to board review. So if you take this language as written, you have taken out board review. The in addition to portion under it, that too is already documented. But the big thing is are you going to take this language as is and take out your ability as the, elected officials to at least review some of these particular changes?
Thank you.
Policy 08. And board members, if you have any comments that you need to?
I might need to make one here.
Yes, sir.
In the, general structure of how the board operates now, I mean, we
Which one?
basically,
The one we just got started on?
yeah,
Okay.
I mean, we basically have three powers. You know, that's to hire and fire the superintendent, be a financial steward of the system's money, and we can set policy. So, you know, and I didn't pull up my stuff and reread the laws under Act One, Act Two, but it was my understanding from previous meetings that I've been to, at any time, the board has the power within the policy to adjust, review, or amend. This is my understanding.
Thank you. Any other board members?
The board has that right to do it, for the policy
Second
change,
change.
that's one of our major goals. If we want to change policy, we change policy, update it,
Alright, policy 08, school procedures. As administrative head of the school to which they are assigned, each school principal may formulate school procedures to ensure teachers, other employees, and students of the school adhere to the requirements established by board policy and the superintendent's regulations and the principal's direction and supervision. The superintendent shall approve the procedures established by a principal. Ms. Harris, do we have any comments online?
Yes, sir. One unanimous. Policy exists in the current document. Where does this change?
Thank you. Do we have any comments from the public?
Yes, and Ms. Bro, do you guys have the CAPS manual available to you? Because if you go under school principals and building administration, what you're carrying down is simply the first line. There are many other tasks related to a principal. Is that now gone? Is this going to be the only statement in there? Because it's significant information in there. It says the principal is the educational leader of the school, opportunities to improve instruction. It's quite a few bit in there. So it's like, what does this one line, one or two lines do for us when we have a significant, robust policy? Are you saying that there's going to be another section about principals? And if so, why is this under school procedures for principals and not going to be tackled in that particular section? Thank you.
Thank you. Any comments from the board? All right, board, at this time, Ms. Broman asked that we didn't have any amended changes, did we, Ms. Harris?
No, sir.
I'm asking the board to approve policy 00, policy disclaimer, definitions and protocols, which to include policy 01, policy disclaimer, policy 02, policy definitions, policy 03, policy manual and policy protocol, policy 04, policy adoption and revision, policy 05, policy suspension, policy 06, policy dissemination, policy 07, district regulations, and policy 08, school procedures. So I would like to get a motion to accept policy 00, policy disclaimer, definitions and protocol.
Motion.
Ms. Brown,
Sorry.
Yes, let's have a motion.
restate it.
Motion, I'd like to make a motion that we, adopt the policy to 0100, policy, disclaimers, definition, and protocol.
I second that motion.
Okay.
Motion is second.
Yes.
Okay. Roll call vote. Dr. Cook,
Yes.
Mr. Hughes,
Yes.
Mrs. Bro.
Yes.
Thank you. The next section we'll be going over is 100, the board structure. First one, and we'll follow the same format we just followed. Policy 101, members. The board shall consist of 7 members elected from single-member districts who meet the requirements established by state law. The single-member districts shall be established following each federal decennial census in accordance with federal and state law. Ms. Harris, do we have any comments from the online?
Yes, sir. One anonymous. Policy exists and is current law. What is the rationale for this?
we have any comments from the public, from the audience?
Yes, if you go to school district organization, or if you go to the laws, to what's currently in the document, there is a header that makes it clear why this information is necessary and needed. This is just random, it's not making any sense. So like if you go to the current, it's under board operations, and then they have, internal organizations, officers, members, duties. So what section of this document, Ms. Bro, do these collection of terms, collection of policies, what will that reflect in this new policy manual? Ms. Bro?
Thank you.
Excuse me, I'm talking to the chair, Ms. Bro?
Ms. Bro, can I respond? These policies are recommended by LSBA based on their analysis of best practices, so thank you.
Thank you, ma'am.
So Ms.
Now,
Bro,
let
sorry,
me just make this clear, I'm kind of confused, and then I want to clarify before we go on. These are things that we need to include, it doesn't mean that we're gonna have to, we can change things in our regular policy, but we don't have to, if what we already have is good and substantial, we keep that.
we don't have to do it,
Is that right?
yes.
Okay.
But you as the chair have to call for that. You can't keep letting him just railroad this. We're supposed to be having a quality meeting. That's why I'm bringing information to the table. I'm asking, what is the purpose of making this change when we already have language that's very robust? I thought we were, as a committee, I'm trying to come to talk to you about what we already have to compare it to what you're proposing. And you just let them make a blanket vote to wipe out everything we already have and replace it with this stuff. This is not a working meeting.
But this stuff that we're talking about, it's not just concrete, this is not. the
Yes,
only thing.
ma'am.
This is- Know what I mean, I don't mean like that, I know if it's stated, that's what we have to do, but we also don't have to follow this exactly as it is.
Yes, ma'am.
No.
Yes, ma'am, listen, yes, ma'am, listen, if you
If
vote
you
this as
think,
policy,
we read somewhere, I know I did, that if you think that what is presented is not accurate, or you wanna make a change in it, you can do that.
but that's what I'm asking you. I'm proposing language to you to change it to keep, I'm asking you, every time I get up here, I'm asking you not to go what's in this, to say keep what you already have. I'm telling you what
But let me
section
tell you
it's
this.
in.
I understand that, but then too, if you keep what you already have, and, as you go along, you may see some things that you wanna
Yes,
change.
ma'am, absolutely, I have some recommendations from changes, but all y'all are doing is just looking crazy, and yes, ma'am, but I'm just saying, and not saying whether or not you're gonna modify this policy, or if you're gonna, so right now, you just voted 1 through 8 to take what they said, now, we don't know what they gonna wipe out.
Thank you. Policy 101.10, filling vacancies. The board shall call a special election for any vacancy for which there is more than 1 year of unexpired term remaining. The board shall within 20 days fill a vacancy for which there is 1 year or less remaining of an unexpired term by allowing the outgoing board member to recommend a successor and allowing board members to nominate proposed successors. In the event of a vacancy due to death, the board shall first offer the opportunity to fill that vacancy to the spouse of the former member. During the meeting in which filling the vacancy is considered, any member may make a motion to appoint a qualified person to fill the vacancy. The motion shall be handled as any other motion, including but not limited to a substitute motion. Each motion shall be subject to a vote. An adopted motion shall result in the person being appointed to fill the vacancy. If 3 motions to appoint fail, the vacancy shall be filled by the governor in accordance with law. Ms. Harris, do we have any comments from the online?
Yes, sir. 1, anonymous, do not agree with this. In the event of a vacancy due to death, the board shall first offer the opportunity to fill the vacancy to the spouse of the former member. Is discriminatory to those with no spouse. Assumes that marriage makes someone worthy to serve. Appoint a replacement and hold an election so the people are represented. A policy already exists with a valid procedure for fulfillment.
I have experience with this board being a former board member, and I think if a board member was to pass and they didn't have a spouse, I think they would at least, seek other So I'm like, I don't understand that statement from anonymous, like, they don't have a spouse, then you can't ask the spouse, so then we probably go to the next
The
step.
next step.
We live up to the board to select
To
some.
nominate, it's nominate.
Do we have any comments from the public?
Yes, I would like to speak on that. First of all, just because you're married to someone does not make them worthy of being on a board. So just having a policy in place that gives you that, your spouse could have all kind of personal issues. And by this, you're offering them that. If they accept it, they accepted it. And you have a rule that has to allow them to sit in that seat. This is not a current policy of this board. Doesn't matter where you came from. This board does not do that. If you go to officers of the board, section BBA, in the current policy, it already documents how to handle vacancies. A vacancy in the office of the president or vice president shall be filled by election. Election is fine, or if you wanna nominate somebody, but you should not blanket adopt. I'm asking for a modification, Ms. Pro, to 101, filling vacancies, to remove in the event of death, due to death, that the board shall first offer the opportunity to fill the vacancy. Just strike that entirely. And then, if you look in, the rest of it is not really a change, but I would like to keep the section of filling vacancies within file BBA, officers of the board that already exist, and strike this information saying that you will just give it or offer it to somebody's spouse.
Do the board wanna make any changes? Committee.
Well, I do know that, what she said, you know, I can adhere to that, but I also know that, you know, in, federal and state programs, a lot of times, and you know if somebody's not qualified, if they're sick or they can't hold a position, but I do know that they have done that. I know that they have had husbands to die in positions, and they put the wife in there. But it doesn't mean that I don't want it written where we have to do that.
No, it says first.
Yeah.
At our discretion.
Yeah, yeah.
Discretion.
Yes,
I
and
want
then
to
we
know.
each other.
They done it in Congress.
Yeah.
Congress did it with Letlow. He died and they put our wife there.
Yeah, and I would trust y'all's judgment on that.
It's a matter of the language of how it's worded. It's not, I don't think it means that it's automatic, the
No.
spouse automatically goes into that position. It's a process that the board goes through.
But
And
it
that's
goes
just
to
one of the
determine, yeah.
processes.
But it
one
would be
of
our
the-
discretion.
In order to put a special election up for the person to be elected in that slot.
So no change, thank you. 101.20, new member training and orientation pursuant to state law, each new member shall complete training on governmental ethics within the first 90 days of taking office. In addition, the superintendent shall ensure members are advised of other trainings required by state law and the documentation and publication requirements of such training. Provide opportunities to complete the training. And if the training is not sponsored by LSBA, the superintendent shall ensure documentation of the members' completion of training is provided to LSBA. Ms. Harris, do we have any online comments?
Yes, sir, we have one anonymous. Already existing caps. Where is the language requiring these certificates to be published in the official journal?
Any comments from the public?
Yes, there's already a policy addressing this, and the current policy is more robust than the policy that is in here. It gives the public a much more confidence in the actual training that is being taken. It requires that the certificates for training be published, which are not being done now, that certificates that are earned are published. If you go on the LSBA site, you can't even tell what actual training you took. It's got a bunch of block hours for conventions, and it might have 1 hour for ethics, but we don't really know what you're being trained on. And then there are specific state statutes and laws and certain things that you should be taking that are probably issuing these certificates. If you're going to be determined to be a distinguished board member, we should have specific language on how a new member is trained, how they're oriented to the board, and how that is documented for the public to see what that training looks like.
Thank you. Any changes from the board?
No changes, but I would like to make a comment. And I know not just you, but other people have addressed the legitimacy of the training that board members get or is required to get. Now, over the years, you know, those that make those decisions have lessened to a degree the number of hours that you are required to have. But I just speak from my personal benefit, and not as a member of this committee, but just as a board member. You know, we get the opportunities to attend conferences and conventions several times a year, especially during and after legislative sessions, where we have the opportunity to get information from legislatures and others that, you know, we would normally have to depend on some outside source to give us the actual fact. And I personally participated in legislative committees by speaking through the LSBA on things of interest specifically for education. That you know, that just gives, you know, an opportunity to be involved in the process. And just, you know, when we have a conference or a convention, usually they bring in speakers that are knowledgeable in a lot of different things, but the best part of those conferences is that after the general sessions, they have breakout sections where you can pick and choose an area that you want to go and not, and I don't call it training per se, but it's garnering of knowledge on how different districts or systems, even in other states, comply with laws and how they work within the boundaries that a board works to take care of daily business. And it's just, you know, to me,
Wealth of knowledge.
it's
Update on whatever.
And usually it's the
it's not,
information
and like I
coming
said,
down the
it's not a
pipeline.
specific training that you getting a certificate on, or like in the educational process, when you get BAs, BSs, whatever, you know, attached to your degree, but it's valuable training information wise to me.
And you know, a lot of part of it is a lot of legislation that, you know.
Right, I
come
mean, when
down
laws
from
change,
legislators, from
they
federal
give you
and
an
state.
overview of what the law was, how it's
Right.
changed, what it means now, how it's gonna affect students or personnel or whatever.
And then Ms. Basha has the ones we do online as well, that
Right.
you can go online and get.
And just, and I'm not gonna say much more, but, you know, I'm looking forward to our next tri-state thing that we have. It's you know, a group of 3 states. So you learn
We had, you know, we had a
how,
ag state too.
how they do, you know, in other states.
Right.
And I'm just
Best
gonna-
practices, best practices.
I wanna say this, probably 8 years ago, I met a lady in Pine, in Arkansas. She had been on their board for almost 30 years. Appointed, she was an appointed board member. And we just kinda got to talking, became friends, and because she was in a school district, basically like the same size as ours, same situations with a charter school that came in, disrupted the thing. After a year and a half, they put a chain on the door, locked it, and moved out. So they were just, that district was just torn apart. But I communicated and networked with her for 6 or 7 years on a regular basis. I think she learned some stuff from me, and I know that I learned a lot from her. And, you know, had I not attended, and the conference was actually in Hot Springs, Arkansas, but she was from the Pine Bluff area. But, you know, those kind of things, when you can go to those events and network with other board members and get get the skinny up front, up close and personal, you know, that's invaluable to me. So, okay, I said enough.
All right, all right, 101.3, annual member training. Each board member shall receive at least 6 hours of training and instruction each year. The training and instruction shall be reported to LSBA. By October 1 of each year, the superintendent shall review LSBA's website relative to the training and instruction completed by each member. The superintendent shall notify each member of any training hours they are lacking or of any deficiencies in the training in which they participated, and the requirement that the training be completed by December 31st. By January 31st each year, the superintendent shall develop and transmit press release to the official journal detailing the information on the LSBA's website concerning the required training and the designation of distinguished school board member. Ms. Harris, do we have any comments from online?
Yes, sir. One anonymous, Sam, it reads Sam, S-A-M, comments as, it's supposed to be same, comments as 101.20. And I'm reading it just how it reads.
Do we have any comments from the audience?
Yes, on 101.3, why are they recommending that you put this on the superintendent? In the previous language, it was up to the board members themselves. Each Bogalusa City board member, I mean, that's how it started, that the members were required to be responsible for knowing if you made the training for the year. This new language says that the superintendent shall review the LSB's website. The superintendent shall notify. How is the superintendent supposed to notify you? You're his boss. Why is this language being written where the superintendent is responsible for the people that he works for being trained or getting the training that's required? Even now, as serving as a secretary of the board, I could see them having to transmit information to the official journal. But why is language being suggested that makes the superintendent responsible for the training that the people that he works for takes each year?
Thank you. Any changes from the board? All right. 102, member compensation and expenses. Board members, with the exception of the board president, shall be compensated by a monthly expense allowance of $800. The board president shall be compensated $900 per month. Expenditure reimbursement, board members shall be reimbursed for expenses incurred while on official board business within budgetary limitations. Travel expenses shall be limited to those expenses necessarily incurred in the performance of official responsibility as may be authorized by the board. Travel expenses will be reimbursed in accordance with budgetary allocations for the specific type of expense. When a private vehicle is used, mileage shall be reimbursed at the rate currently in use and approved by the board. Any board member who submits a false or fraudulent travel claim shall be subject to disciplinary action, and the board shall be entitled to restitution in full pursuant to state law. Ms. Harris, do you have any comments from
Yes, sir.
online?
One anonymous, does this remove the extra compensation allowed in the current policy, missing revised statute 1781?
Again, these policies will replace the old policy language once approved by the full board. We have any comments from the public?
Ms. Rowe, the current policy under board member compensation and expenses, BBBE, not only covers what you just have here, it also has the policy for how the board can increase compensation. So again, why are we paring down language when we already have language that is very comprehensive and it is under a header of board operations, so you know how it is being used? So why is it that, what value is this when it doesn't cover how you actually take this action? You can't give yourself a raise based on this language. You can't do any kind of adjustments without going back, creating new language, and then trying to take action. So why not keep the current language? Any action increasing the compensation of the school board member shall require a 2/3 vote by any action taken. I mean, it's really comprehensive. It says how you can give yourself an additional $150 a month expenses. It doesn't mean you have to invoke it, but the language is there so that the policy is documented, so you don't have to come back to the board as the committee. and come up with language to cover a situation that we already have. We're getting less than what we had. Why? Why is this acceptable?
Any change from the board?
I would like to make a statement. To be good stewards to our constituents, I personally don't want the ability to give myself a raise. I think it looks better if that's not on there, and I actually like it.
And I would double check board, legally, you can only do 800 as the max, and the president get an extra 100. So,
That's it.
and if you gave yourself a raise for $150, you'd be all over Facebook and it'd be a
Right, right.
All right. Policy 103. At the first voting meeting in January of the first and third calendar year, the board shall elect a president and vice president. The president and vice president shall serve for a term of 2 years. No member shall be allowed to serve as the president of the board for more than 2 consecutive terms unless no other board member is nominated and receives a second. At the first voting meeting in January of the first and third of a 4-year term, the board shall elect a president and vice president. The duties, there's a typo here, I wanna reiterate. Duties of the vice president, it should say the duties of the president.
Right.
That's a mistake. In addition to those set forth in law, shall include setting the agenda of the regular and special meetings of the board, appointing the membership and chairperson for all board committees, serving as designating or designating a spokesperson for the board, and serving as the presiding officer of all board meetings. The duties of the vice president shall be served in the place of the president at all board meetings and committee meetings of the board in the absence of the president or upon request of the president. Pursuant to state law, the superintendent shall serve as the board secretary and treasurer. Ms. Harris, do we have any comments from online?
Yes, sir. One anonymous. Disagree. At the first voting meeting in January of the first and third calendar year, the board shall elect a president and vice president. Disagree. The president and vice president shall serve for a term of 2 years. Keep current policy of 1-year term and vote every January. The people are basically stuck without any recourse for 2 years. Are these the duties of the president or vice president? Looks incorrect.
Any comments from the public?
Absolutely. If you go to officers of the board, file BBA, it is clear in here that you should elect them both city school boards should elect this regular meeting in January each year, one of its members to serve as president. Ms. Bro, we just had this. Why would you let this go on? They didn't even suspend this rule.
I was just one person.
Yes,
I
ma'am, but I'm
couldn't
just
do
saying, right
anything.
now, this is where you can address that. If you let this language go, what happened becomes the policy of the board. It overwrites what's already in here. And then if the people have a problem with the president, at a minimum, if you vote every year, you can at least bring those concerns to the record. As they wanna change the language, you sit in that position for 2 years, and that's just it. Then the superintendent is already the secretary and treasurer of the board, as identified by, policy. I don't really understand how giving somebody this spot for 2 years and not at least bringing it back so that the people can make comment on the motion, comment on how things are done, puts us in a better place as the public. It does wonders for the 7 people on the board, but it doesn't give the public any opportunity to say anything for 2 years. You're just stuck with it. So modify that, retain the language you already have in file BBA, already in officers board shall elect at its regular meeting in January one of its members, and then it has a lot more detail in here about the role in the secretary, as the secretary and treasurer of the board of the superintendent.
Would you propose any changes? Again, this won't.
What is our, policy now?
Currently is, we changed it to 2 years.
Yeah.
No, the policy of both city school board, officer of the board, BBA, the Bogalusa City School Board shall elect at the regular meeting in January each year, one of its members to serve as president and one to serve as vice president. Now they wanna change it that every 2 years they vote. I'm asking you not to vote, not to strike that. No, that's not right. So just because you didn't follow the policy policy don't mean that it was right.
And some of the reason for the 2 year is that every year, we have to change signers on the bank account, and I think in the minute of doing the 2 years, it's, we don't have to go restructure all the payroll accounts, all the security fund accounts, we have to go change every signature on the bank account. If we change the president every year, which, if we have to do it, we have to do it, but that was some of the reasoning when we went to 2 years.
Well, the people
And
lose,
Congress.
the people lose.
And the parish and other agencies did it.
It took me 2 years to get your feet underneath you, you know, as the president, especially if you're a new one. It takes you a little while to learn the role, grow into the role, and then by that time you have that experience, and then boom, you're done. You know, I think 2 years is a good time to get in there and put that work in.
And I
That's
think
just
the
my
board had
opinion.
the option of, if they decide they don't want that president,
They had the
they can come
option
back and
to-
say, we wanna change the policy to 1 year at any time. And we're not locked into these policies, am I correct?
Yeah,
Okay,
the board can
so
change the policy.
If you see have a president that you're not pleased with, I think the board as a whole
Right.
can come and say, no, we don't want that policy.
True.
So the way it works, if anybody in the committee wanna make that change, you make a motion
Yeah.
to make that change now in the committee. If you get a second, then it goes for a vote. If it don't get a second, it dies for lack of support.
I don't agree with the way it was handled. I think it was done incorrectly, and, I have nothing against, Reverend Cook. In fact, I love Reverend Cook, and I mean, if we had done it correctly and he had gotten it, I wouldn't have a problem with it, and I still don't have a problem with it. But I just think that we didn't do it the way we should have done it. And as I've told you, I haven't done it yet, but I am gonna write the ethics board in their opinion. I just want things to be done correctly. And then
I'll
it says
speak on
on
it.
here that we're not supposed to serve over 2 consecutive terms of president.
I speak on
That's
that.
the new policy.
If that's a new policy they just created, if Mr. Creel wouldn't have wanted to resign, he'd have still been vice president. Just because he resigned, that's why we had to get a new vice president.
No. When we had that meeting, Mr. Creel had not resigned. Mr. Creel said he had a letter, he had not submitted his letter. So at one point, we had 2 vice presidents, which is illegal. He had not resigned at all.
He resigned that night.
I did.
This is after though.
No.
This is after, but yeah, that was after, during the meeting.
This was my thought process, and I could have been wrong, but I did not even talk with the superintendent. I talked with the president of the board and explained my situation to him with the issues that I was facing and the unknown.
And I understand all that.
And we
Mr.
had
Creel.
that conversation. And as far as me talking to Dr. Cook, the only time I ever said anything to Dr. Cook was a month or 2 before that at the LSBA thing we had in Covington. And the only thing I said, it's time for the new board members to step up and
But, and I
get your feet
understand,
wet
Mr. Creel, but you know what?
but, you know, and I don't wanna
No,
go back.
Me either, but I see what you're saying, but Mr. Creel, you know what? We've had new board members before, and we still got the old board members every time. So that can't be the justification, is what I'm saying. You know what I'm saying? And I'm just being honest
What,
with you.
and here's my 2 cents about
Okay.
that. Now, you know, if the general consensus of the board is that an individual that's holding off is doing the right thing and doing the job, that's fine, but you know, he's limited to 2 consecutive terms.
That's right.
But just like, you know, myself, you know, when I came on the board, I was retired. I didn't have to go to work every day. I had time. And from after the first year that I was on the board, I was an officer, president or vice president for 14 years. You know, I think I served my time.
But do you think that was legal?
Well, it was by nomination, by vote of the board, so,
Okay.
It was
I'm
legal.
gonna let it go, you know,
Yeah.
that's in the past.
yeah.
I'm gonna
Well,
let it go,
and that's what we
but I
need,
just
that's
have-
what we need to do.
yeah, but
Yeah.
I just want to
I
express
understand.
myself, but I'm through with that.
And, you know, personally, I agree with what Mr. Hughes said about, you know, you take a position, then it's a learning curve, it's a process. And, you know, decides they want to campaign for the presidency job, and you get booted out, and, that's politics, I guess.
But I also asked all the new members if they wanted to be president.
And I think that's illegal.
So the proper thing now is, if you wanna change the policy
That's
to
illegal.
say 1 year terms or 2 years, we have to make a motion. So if anybody
Because
wants to
what
come
you
in,
did, Mr. Kate, you included everybody but me, and that was not fair.
You want 1 year?
I don't know anything.
do you want to make a motion to amend it to 1 year?
For what?
Serving as a
Term.
president or vice
No,
president?
I think 2 years is adequate.
Okay,
I think 2 years is adequate, Dr. Hurst. Yeah, it gives that person a chance to get in there and learn and, right, I don't have a problem with that. It's just like superintendent, you don't really start
No.
really feeling stuff till about your 3rd year.
Yeah.
So no, I don't have a problem with that.
alright, we'll move on to the next one. Policy 104. 100 board committees. I'm not gonna read this entire document, but I'll read a snippet of it. The board shall have the following standing committees, the purpose of which is to make reports to the board on issues related to the subject matter assigned. Finance committee, buildings and grounds committee, policy committees. And what I'll discuss, select committees, the president may create select committees to hear matters, I'm reading out the bottom. Hear matters of specific concern and provide a report on the matter to the full board. The president shall provide the purpose of the committee, the manner for appointing members, and the chair of the committee, and the duration of the committee. However, the duration of a select committee should not exceed 1 year. Committee as a whole, committee of the whole may be created by the board. Committee of the whole shall include the entire membership of the board, with the president serving as a presiding officer. Action by the whole committee shall not be considered as an action by the board. Ms. Harris, do we have any comments online?
Yes, sir, we have one anonymous. Missing committees currently established, doesn't define committee over council, gives president too much authority to interfere and influence committee operations.
Thank you. We have any comments from the public?
Yes, this, if you actually read this and you look what's under it, it doesn't make any sense. So it says that you should have the following standing committees. Then it lists all these committees, and within listing that, it has select committees and committees of the whole, but then it says the select committees, the duration is only a year. So they can't be standing. They would have to be their own section outside of the language. It doesn't have your personnel committee, which is a standing committee. It doesn't identify who is the finance chairperson. Is that a person on the board? Cause you have a CFO, so is the CFO automatically on the finance committee as a non-voting member? I mean, this is because you took somebody else's language, and we're not sitting here talking about how Bogalusa City Schools operates. This doesn't even make sense for us. You have to go through and say what you have, and then take what they gave you as a template and write it to how we operate. We don't operate this way. I don't even know who the finance chairperson is right now. You have a finance committee, but your CFO, you would think your chief ops person would be on your finance committee as a non-voting person. Your personnel HR person will be on your personnel committee. Trying to take template language without doing the work of looking at how you operate and massaging it to make it how it works is just a waste of time. It's a waste of time.
Any recommended changes from the board? Just to clarify, board, for understanding, the standing committees, and I think the board talked about this earlier this year. It's just 3 right now: finance, building and grounds, and policy committee, which the board president could select those members of those committees, and we do have those 3. A select committee, if there's a special issue going on, the superintendent, the president can create a select committee for anything special that may be happening. The committee as a whole, is if we decide to do a committee as a whole, with everybody be on the committee, you can have that choice. So if there's no recommended changes, any questions from the board, we'll move next to the next one. 104.10, advisory groups. The board shall have advisory groups as mandated by state law, including special education, school health advisory, substance abuse, instructional material review, discipline policy review. Additional advisory groups shall include the teacher advisory council, the parent advisory council, and others created by the president. Unless otherwise specifically provided in law, the president shall provide for the membership who may or may not be board members, method of designating the chair, manner for calling meetings, subject matter jurisdiction, reporting requirements to the board, method for termination and termination date. Unless otherwise specifically provided in law, all advisory groups shall operate under the open meetings law in accordance with the rules and procedures adopted by the board. We do have this, just for reference board, we do have a special advisory committee that Ms. Warner has started. Mrs. The school health advisory committee, Ms. McNabb got that started a couple of weeks ago. Instructional material review, that's under Ms. Tillman and her team. Discipline policy review is, of course, Ms. Mingo, what she's working on now. And substance abuse prevention team, that's something I really have to look at, because I don't think we created that, but I'll check with Ms. Mingo, since she got that within her purview of work. Ms. Harris, do we have any comments from online?
Yes, sir. One anonymous. What is the difference in councils versus committees? Should require the board to solicit membership and resumes submitted. The board should vote on inclusion to council and be documented in the minutes. Councils should have a fixed members.
Thank you. Any comments from the public?
Yes, the current policy requires that people submit resumes in order to be on there. It doesn't just leave it up to the president to just tag people, because all that does is, if you don't like how the committee is going, you just stack the deck and keep putting people on there. This language is dangerous. It does not provide us the ability, the people, to really see who's getting on these boards, these councils, what their abilities are to provide for the community, to have growth. I mean, this is really pretty much written that at the will of the president, you can just stick people on committees, and then on councils. And then it doesn't even identify all the councils, some of which are in this documentation already, that Bogue City Schools is supposed to have that they don't have. Another thing is that this does call out open meeting law, which means that all of these groups should be advertising their meetings. They should have written meeting minutes that I have asked for some of them, and haven't gotten. We never see any documentation from these groups that they're meeting, in addition to the work products that they're producing, which would have to come back to policy committee to be put in place. So there's some language missing in here in how these groups, they're calling them advisory groups, but then in here they're being called councils. It's just a lot all over the place. You got committees, council, groups. What is the purpose of this when we already have language that documents how to get on these committees?
Any request to change from the board? Thank you for your comment.
Yes, I do. I don't think that, I think we should have probably resumes or some kind of letter, and I think it should just not be just one person that chooses them, because that's giving that person too much power.
Decided by the board then.
Yeah. I just don't believe it.
Just for the record, the current committees that we have are councils, whatever you may call them, special education, school health advisory, instructional material review committee, discipline policy committee. The persons in that department, they follow a process to select, individuals to be on that, on those committees. So the board has not selected any of these committees or solicited. So for example, Ms. Mingo has strict guidelines that she has to follow as who has to be on the committee. She seeks out recommendations from principals and different organizations to see who wants to be on the committee. That's her committee.
That would be considered more day-to-day, correct?
Yeah, like Ms. Warner, she followed a process to set up a special education advisory council.
That makes sense.
Ms. McNabb, she set up a process to select her school health advisory council. But I do want to advise the board, I have my own advisory councils with the employees and the students, and that is not subject to open meeting law, so that is my council, not the president's. So I just want to be clear on that.
That makes sense.
All right, any proposed changes? All right, thank you.
Sounds like a misunderstanding.
And 106, state association membership.
I do have a question. I want, cause it's about like, suppose down the road we wanna do
directs us to set up a finance advisory council, then that's subject to open meeting laws. But if you say, just for your knowledge, you wanna set up a finance advisory council, then that's your advisory council to help you, and it's not subject to open meeting laws.
And it's not part of the finance meeting, it's
Yeah.
like a council, yeah.
Yeah.
There you go.
Policy 106.
105.
Got
105. 105.
Yes, sir.
Oh, board attorney. The board shall engage on contract a representative licensed attorney or law firm to serve as the board's general counsel. The board may engage special counsel when necessitated, got tongue tied there. The engagement shall be pursuant to state law. Just for the record, board, we have a contract with the district attorney that sends an attorney, and they chose the attorney, Mr. Matthew Garber. We do not have a contract with Matthew Garber. We have a contract with the district attorney. We send a check to the district attorney, and they chose to send Mr. Garber to be our representation. Now, in special cases, when we have lawsuits, that's dealing with HR or something else, we can seek out attorneys who specialize in those areas, as opposed to the district attorney's office. So it depends on what's going on. We may have to seek specialized counsel because they're the experts in that area.
And who is the counsel for the LSBA that helps us too?
Hammonds and Sears. They use,
Is it Hammond and Sears? I don't know.
that's who we.
They have a lawyer though.
But we do different things with
Different
Hammond and
things with
Seals.
Hammond
We have
and
several different type of specialized counsel. For instance, I'm gonna give you one like Foley Jadeo. They are our counsel, but to do all villages, they specialize in that. So
Right.
they do that type of counsel. And when we do bonds and et cetera, they handle that. Now, if we have a lawsuit like with students or separate, we go through our liability company, which is Lawman. They handle all that for us. So they have their own attorneys inside of the premium we pay with Lawman. But if it's outcome, we do have to pay additional amount, you know. So
That's fine.
we do have specialized.
So it all depends.
And I also know too that if we have, even though the district attorney, I found this out a long time ago, is, they appoint somebody to come and work, and we don't want that person, we can ask for another person.
Yes, sir.
You know, keep that person.
Yeah, we'll speak to the district attorney's office about that, if that was the case.
Yeah, I'm just saying, yeah, no, I don't have a problem with it, I love it, man, we got
I
it.
do too. Look at him, he's up there listening to it.
That's my boy,
That's your boy.
But I'm just saying, you know, if you did.
Can he-
And he's speaking on.
You got sound,
Yeah,
Can't
he
hear.
does. He's gonna have something to say about that,
Yeah,
right?
he's probably got to turn his on.
He knows you love him.
Turn your, are you
Gotta
muted?
get that
Sound on?
smile out of it anyway.
There we go. I was gonna say, I hope Ms. Bro wouldn't do that to me.
Oh, I know, and y'all was wrong for that. They didn't let, but you know, you heard how I love you, though.
Under her voice, she did say.
So now,
But no, just to Dr. Hurst's point, that is correct. The district attorney's office appoints counsel for kind of your day-to-day and to come to the meetings as I do. And then if there are specialty issues, typically Hammonds and Seals is who I recommend, and I think who you guys typically deal with, because they specialize in school law and public body representation for more complex issues.
Tell me what you said under your breath.
but you know, now, I didn't know they were doing me like that, but you know I love you, though.
She said I wouldn't make a change.
You know I would.
Okay, so any proposed changes from the board on that? All right, last one in 100 is 106, State Association membership.
Dr. Hurst, I do have a public.
Oh, I'm sorry.
Yes.
It's coming, I'm sorry.
This is an anonymous special attorney mission 42-262. AG approval required, plus disclosure of fees. How often it board attorney voted on, and it doesn't document how they are selected.
I think we just explained that. Do we have any comments from the public?
Now you know.
Yeah, you verbally explained it, but it is not in the language that is proposed. So after today, who would know? Because it won't be in the policy. The current policy indicates the role and responsibility of the board attorney in file BBE. In addition to that, like I said, there is a follow-on statute 42-262 that is very specific about how to go about getting special attorneys, and it requires a resolution. And this board has done a resolution. In July, I think you sent me, July of 2023, you got some special counsel, said you did a resolution for it, or whatever, but this is very vague compared to what we already have. that documents the role and responsibility of the board attorney. Now, it does not have the language that you're including now, that the board may engage in special counsel. But if you are gonna use special counsel, I recommend that you also add 42-262 that gives the people the link to how that should be done and how that should be carried out by the board.
Thank you. 106, the board shall maintain membership in the Louisiana School Board Association. The board's annual budget shall include LSBA's organization dues and the cost for members to travel to LSBA state meetings. Do you have any comments from the, online, Ms. Harris?
No, sir.
Any comments from the public?
Wait, yes, sir, I do, I'm sorry. Anonymous, not a current policy, what is the rationale? How much does dues cost? How often do they travel?
Thank you. Any comments from the public?
Absolutely, I'd like to expound on that. This is not a policy of Oklahoma City School Board. How much have we spent on this so far so that we know how the annual budget will be impacted? And how much is travel generally to these state meetings? How much does this cost us? Because this isn't something that we have, and per LSBA, clearly, they say this is optional. This is not required to be in a policy manual for Bogle City Schools. So why is it being recommended? Ms. Rhodes, Chair, what is the purpose of adding this information when LSBA themselves said that it's optional? This is not required to be a policy of Bogle City School Board.
Would you like to make that into a relationship with LSBA?
Thank you for your
How
comments.
much does it cost us, Ms. Bro? How much to the policy
Oh,
committee,
that
this
has
being
to go to the small-
proposed?
I don't know.
How much, it says we have to put a line item in our budget for them now. And we already have a travel budget, and that travel budget is open not just for them. So my question is, does this also require us to have a travel budget for LSBA specifically? Or will this travel just be included in the lump travel that we already have for the board?
It'll be included in the line item of the travel.
And how much is the annual dues?
I can't tell you right off, but I can get it to you.
Thank you.
All right, that concludes section 100. Board structure. Ms. Broma asked for a motion to approve section 100 board structure. Ms. Harry, do we have any changes?
No, sir.
Okay. I asked for a motion, can you ask for a
Can I
motion?
get a motion, to approve 100?
I'd like to make a motion to approve 100 board structure.
I second that motion.
It's been first and second. Can we get a vote?
Yes. Dr. Cook,
Yes.
Mr. Hughes,
Yes.
and Ms. Bro.
Yes.
All right, next section is board meetings. We have a few policies in here. Policy 201, regularly scheduled meetings. The board shall meet in regular session at least once monthly pursuant to state law. The time, date, and location of all regular meetings shall be scheduled for the entire calendar year. The schedule shall be adopted by the board by December 31st of each year. The adopted schedule shall be published in the official journal and posted on the board's website. The time and date and location of a scheduled regular meeting may be changed upon the majority vote of the board. Any change shall be properly noticed in accordance with the state law. Ms. Harry, do we have any,
Yes, sir.
comments from?
One
All right.
anonymous, remove date subject to change from current meeting agendas. Date change requires a vote and still need 24-hour notice.
Any comments from the public?
What section does 200 cover? What, Ms. Bro, what is this section now? You've moved on to an entirely different section. What does this grouping of policies cover?
This, you talking about regular meetings?
No,
Board
no,
meetings.
this, you're on 201,
Uh-huh.
which means that this should be a section 200. What does this cover? What does this collective group cover?
Board meetings.
There's already a section within the current school board meetings, file BC, which is pretty robust. it documents the same information in addition to, it provides the time for the meetings, it goes over the quorum. I mean, this language is pared down from what we already have. What's the purpose of taking away language that gives the people an understanding of how these meetings, how the board operates? In addition to that statement about removing the date subject to change, you cannot just change meetings without a motion and a vote. So there should be no documents going forward or right now that say date subject to change unless they say subject to change by vote of the board. Thank you.
Thank you. Any changes recommended by board? All right.
Dr. Hurst, may I say something briefly?
Yes.
I just wanted, and not so much on the current, line item that you're dealing with now, but just for the board's sort of consideration. When the LSBA puts these things together as sort of the model rules, a lot of that is about promoting uniformity amongst many of the school systems. And that can be important from a legal perspective too, just be aware, because when we have these, when courts are called upon to interpret certain policies and procedures amongst the school systems, if they have a similar, if there's uniformity, then that decision is gonna apply to all systems, right? And as these systems have their own ad hoc policies, you sort of, it sort of eliminates the uniformity and eliminates the ability of the courts to uniformly interpret the rules. So that's just food for thought as you guys are going through this process.
Thank you.
Thank you.
Policy 201, special meetings. The board may hold one or more special meetings in a month. A special meeting may be called by the president, by the vice president, and in the absence of the president, upon a written request of a majority of the members of the board. A special meeting shall be noticed in accordance with the state law. Ms. Harris, do we have any comments from online?
Yes, sir. One anonymous. When is notice not required?
Any comments from the public?
What notice is required on special meetings?
Yes, it's the same as any other meeting, 24 hours, right? All right.
So, I mean, I guess why isn't that spelled out in here? I mean, you have the open meetings law in here, but realistically,
A special meeting shall be noticed in accordance with state law. The state law is 24 hours.
correct,
All right.
yes, but in the previous iteration of documenting board meetings, it was made very clear so that an individual was not required to have the internet. They made sure in the meeting notice, you could read and know what your rights are related to the policy. Right now, this strictly limits you from, all you know is state law. You don't know what your rights are in relation to this policy. You don't know how people call a special meeting. It's just a one-liner, and either you have the internet or you don't. And that's not good for our community, considering the number of people that we have that are on cellular devices, don't have access to the internet. I mean, we are facing some times here where people may have to give up the internet, and we are putting in policies where there is just basic garbage and you don't know anything. You won't know how to interact with this board.
We might use your podcast to help get the word out.
They can always.
Trust me,
Oh,
I'm gonna use it.
Policy 2012.
Oh, it's gonna
A
get
board
used.
meeting may be,
Oh, excuse me, Dr.
sorry, Mr. Creel.
Would it be acceptable at the end of that last sentence, in parentheses, put 24 hours notice?
So it will read, a special meeting shall be noticed in accordance with state law within 24 hours.
Yeah.
We're gonna need a motion to add that.
The only thought I would have on that, is just again, if the state law changes, you'd have to go back and amend this policy. Whereas as written, you wouldn't have to amend the policy if state law changes.
So in other words, we can do it as we got it now, as state law, say.
Correct.
Alright.
Okay.
Alright.
Good.
Policy 201, a board meeting may be conducted via electronic means during a gubernatorial, declared disaster, or emergency pursuant to state law. For each meeting held by electronic means, the board shall provide a mechanism to receive public comment electronically both prior to and during the meeting. Properly identify and acknowledge all public comments during the meeting and maintain those comments in the record of the meeting. Ensure that each person participating in the meeting is properly identified. And ensure that all parts of the meeting, excluding any matter discussed in the executive session, are clear and audible to all participants and the public. Ms. Harry, do we have any comments from online?
Yes, sir. One anonymous. Is this not documented in the current policies?
Do we have any comments from the public?
Again, the current policy provides for much more robust language in teleconference remote participation in school board, file BCAD. It's very specific about how to handle emergencies and disasters, how remote, participation with members with a disability, and it has some very specific definitions, what I was asking for in the beginning, about what different things mean, what teleconference means, what video conference means. Why are we paring down language and putting people in a position where they're not going to be able to go to the policy document and really understand how this board operates or what their rights are? Thank you.
Any recommended change from the board? Thank you for your comment. Policy 202, notification and posting of the agenda for all board meetings shall be pursuant to state law and rules and board policy. The superintendent or their designee shall ensure proper notification is provided and that the agenda is posted for all board meetings. In cases of extraordinary emergency, when state law does not require notice, the superintendent shall provide appropriate notice as circumstances permit. Ms. Harry, do we have any comments from online?
Yes, sir. One anonymous response. When is notice not required?
Any comments from the public?
In the previous policy, agenda preparation and dissemination, BCBD, it was very specific about when and how to interact with the board to get stuff in. So it told you what time you had to have it in. It told you how to petition the board to get information on the agenda. I mean, notification, it was just very helpful for somebody who might be new to the area to know the policy that the board has for these things. Why are we eliminating those things? Yes, I don't see how you would find yourself in a lawsuit having a problem by letting people know that in order to get notification, they need to follow the new state law that says that they need to put in a records request or they need to put in a request to get these notifications of meetings. I mean, yes, things have changed, but even those things aren't being incorporated in this documentation. Thank you.
Thank you. Any recommendations or changes by the board? All right, next policy 203, meeting agendas. The content of the agenda of each board meeting shall be determined by the superintendent with approval of the president. A board member may have an item added to the agenda by providing a written request, including via email to the superintendent not less than 72 hours before a scheduled meeting. The agenda shall notate any matter requested by a member. Once requested, the item may be removed from the agenda only if the member who requested the inclusion of the item makes a written request for such item to be removed from the agenda prior to posting. The superintendent shall ensure the agenda of each board meeting is prepared and posted pursuant to state law and rule and board policy. Ms. Harris, do we have any comments from?
Yes, sir. One anonymous. The current policy encourages both the public and the board to invest more in developing an agenda. However, this language removes any rights currently afforded to members, like adding items until 5 p.m., 24 hours before the meeting.
Any comments from the public?
This is critical to the working relationship between the board and the public. In the current policy, it says a request to be considered for a place on the agenda of any items by any group of individuals other than a school board member, administrator, or employee shall be filed in writing with the superintendent no later than 5 working days preceding the next scheduled board meeting. You are eliminating the people's policy documentation that tells the people how they can come to you and submit information that they wanna have you see and take up as the board. This language should be retained on how to request consideration for the public, not just the board members, how the public can interact with you, how they can come and conduct bus business. That looks at all of these civic groups that come in here. Right now, if they don't go to the president or they don't go to just the superintendent and say they wanna be on here, the policy says those are the only two people. You had a rule that said that at least they could submit and it would get on the agenda. You might not get your vote, but it would get your time. So why are we taking away that type of language in the new policy? Why is there no documentation on how the public gets on the agenda? How the public can ask and request to speak to the board?
Any recommended changes from the board?
I had no problems with any of my constituents getting anything to me to be able to bring to the president.
I think basically what we do, somebody comes and notify the president
Yeah.
with the information that needs to be
I haven't
addressed.
run into any issues.
Even if the public come down there, they'll go to the superintendent secretary and she'll call me and we'll, address that.
No issues.
Issue,
Not, the public always have the right to come to be on the agenda.
And they do.
To deal with their issues.
And they do.
And they do.
And especially when we're dealing with civic organizations,
Mhm.
we also we wanna include them to get information out.
100%.
But when it's the public, they have complaints, we gotta make sure they go through the proper protocols.
Well, just like I asked you in your office earlier, I thought we're gonna have to amend the agenda for the sheriff's office to give a presentation about the, summer camp.
Yeah.
Washington Parish summer camp from the sheriff.
But what we don't want is a upset parent who hadn't talked to the principal, hadn't talked to Ms. Mingo, hadn't talked to anyone, come straight to the board meeting
Right.
and get on the agenda. Because we can resolve those issues.
Yeah.
At the
In the
school
super-
level.
yeah.
Yeah. All right, any changes, all right, policy 204, meeting procedures. Open meetings, the board shall comply with the requirements of open meetings law. The presence of a simple majority of the board members shall be required to conduct a meeting of the board. Executive session, an executive session of the board may be held pursuant to state law. Executive sessions shall be attended only by members of the board, the superintendent, and any other persons designated by the board. All matters discussed in any closed meeting shall be regarded as confidential by all persons in attendance and shall not be divulged to the public. Member participation, a member of the public body who has a disability recognized by the Americans with Disabilities Act shall be allowed to participate and vote in a meeting via electronic means. A member with the ADA recognized disability shall request to participate electronically at least 2 days prior to the first meeting for which they have requested accommodation. The electronic means utilized shall provide the member the capability to fully and openly participate in discussions, make motions, and vote. Rules of order, the board shall utilize Robert Rules of Order. Voting shall be conducted by voice or at the discretion of the president by an alternate means. All votes shall be recorded in the board's minutes. All proceedings open to the public may be recorded, filmed, or broadcast live. The superintendent shall develop regulations relative to the use of lighting, recording, and broadcasting equipment to ensure proper decorum. Written minutes of all open meetings shall be kept and published in accordance with state law. Ms. Harris, do we have any comments from online?
Yes, sir. One anonymous. These are already policies in place. What is the rationale for this language?
Any comments from the public?
The only, person, Mr. Tress, is in member participation would be board members. When will you get to how the public ask for ADA, accommodation? Where's that particular language? If we're talking about how meetings are to be conducted, how you can, participate in meetings, this language is strictly for members. It does not give the instructions for the public. So when will that be addressed? If this is how meetings are conducted, Ms. Pro, if this is how you participate, where's the section for the public? Where's the language for the public?
Thank you. Do you have any recommended changes for the board, from the board? All right. participation and public comment. In accordance with state law, the public shall be allowed to comment on any action item on the agenda prior to the board considering the item. A person desiring to make public comment shall complete a public comment card provided by the board and include their first, last name, home, street address, and agenda item to speak of. Comments shall be respectful, avoid vulgar or inflammatory language, limited to the subject matter of the agenda item, and limited to 2 minutes in length. Remote comments by certain persons. Pursuant to state law, persons with a disability or their caregivers shall be given opportunity to provide public comment. The board shall allow any person with a disability recognized by the Americans with Disability Act or a designated caregiver of the person to make a public comment by submitting an email containing a public comment to the following email address. And we will place the email address on that, where we want to send it to. The email shall list the agenda item the email is regarding, be received not less than 2 hours prior to the scheduled start of the meeting, be not more than 500 words, include the sender's full name and home address, provide the nature of the ADA recognized disability and the relationship to the person with the disability. The superintendent shall make the final determination on whether the email meets the board's criteria. The email shall be provided to each member prior to the start of the meeting. The superintendent or designee shall read the email into the record during the public comment portion of the meeting for the related agenda item. In the event that there are numerous emails that are substantially similar, a representative email and a list of the person who submitted the substantially similar email shall be provided to the members and read into record. The superintendent shall make the final determination on whether the email meets the board's criteria. The email shall be provided to each member at the start of the meeting. The superintendent or their designee shall read the email to the record during the public comment portion of the meeting for the related agenda item. In the event, it's kind of like redundant language, so I might have to look at that. Another typo on my part. In the event that there are numerous emails that are substantially similar, so that's the same thing we already write.
Right. You should cross the last part.
Yeah. So, Ms. Harris, do we have any, comments online?
Yes, sir. One anonymous. Current policy give the public 3 minutes. Why is there an attempt to reduce to 2 minutes? This prevents the public from having enough time to express themselves. Nothing in this or the current policy prevents someone from getting a comment card at any time during the meeting.
Any comments from the public?
Absolutely. Mr. Grove, you got this, you cannot reduce the amount of time that people get at the mic to 2 minutes. It's already hard enough to formulate, your thoughts. You already only get the information mainly sometimes 24 hours before the meeting. Then they want you within 2 minutes to be able to say what? It's very few people that even come to these meetings, and now you start taking down the time, that's just gonna push more people off. Second, that's what I was asking in the previous, comment about the ADA comments. This is 2 hours before the meeting. So, is there going to be like, documented how they contact the board, like how they participate? Like, this is just sending your comments, but what about people that wanna participate in the meeting remotely, that's the public? There's nothing in this policy that says how they go about doing that, except that 2 minutes before, 2 hours before, I'm sorry, they can send an email saying what comments they wanna make. But what if they wanna be on Google Meet? What if they wanna do like this back here? Where's the policy that tells you how to request to be within the meeting? Thank you.
Any recommended changes from the board to this policy?
I do think that, 2 minutes is just not enough time. I think should stay 3 minutes, you know, because a lot of times when, they have the 3 minutes, President Cates have to stop them and they have not concluded. And if you got a concern with the board, you should have at least 3 minutes to talk about it.
So the board wanna make it 3 minutes committee?
That's what it's always been, 2 minutes.
So this currently says 2 minutes, so the board, the committee, get a motion to make it 3 minutes. We get a second.
Can I get a motion, from the, committee to change the 2 minutes to 3 minutes per board meeting?
he's not going to be approved until a few months down the road, so we still have time to revisit.
I just think, because public, this is their system, and they have a right to express their opinions. And you can't base things on what you feel about maybe a particular person. I mean, you gotta do the right thing. 2 minutes, you can't do anything. Now, when you give those presentations, like, Mr. Cates has recommended that the sheriff comes here, do they get a number of minutes?
Well, they're on the agenda, so.
I understand that. But
These-
that's just not
Kinda
fair. I don't
They're
think
not
it's fair to
limited.
people. It's like you're pushing the public out. You're pushing the public out of the local school. I don't think we should be doing that. I don't agree with that, but I mean, if that's what the majority, wants, as always, I'll stand alone. Okay.
No changes? Yes, that's all. Official journal, policy 205, during the month of May of each year, the superintendent shall solicit bids from all newspapers that meet the qualifications set forth in state law to serve as the board's official journal for the upcoming fiscal year. Superintendent shall submit all bids received to the board at the board's first meeting in June. The board shall select the official journal. Superintendent shall ensure that within 20 days from any meeting where official proceedings are held, that a copy of the minutes and other statutorily required documents are sent to the journal, official journal for publication. Ms. Harry, do we have any comments from online?
Yes, sir, we have one anonymous. The current policy is better and supposed to be more comprehensive. What is the rationale for this recommendation?
Any comments from the public?
What is the rationale for paring down the language from the current language? Why do we need less language when it's really more, what we already have indicates to the public how the journal is selected, what gets published in it, what happens, so you can basically go to the policy manual and see, as someone in the public, how you're supposed to be using the official journal. Right here is pared down to like 3 lines, just basically minutes, and it just says required documents.
Any change recommended by the board? Okay, Ms. Bro, Max, can you ask for a motion to approve policies 200 board meeting?
Can I get a recommendation from someone to approve policy? Board meeting 200,
I'm going to move the motion that we accept policy 200 board meeting.
Second.
You got a second?
Yes.
Let's get a vote.
Dr. Cook,
Yes.
Mr. Hughes,
Yes.
Ms. Bro.
No.
All right, board, I'm gonna ask that we, stop here and we'll visit 300. We'll schedule another policy meeting. This is our first attempt at this, and we're doing a policy, so we can see how it varies. It's also gonna be, and the reason I'm asking, because we do have a regular board meeting tonight at 5:30. So to give everybody time to go home, get a break, grab something to eat, and we'll come back with our, Business and Ground and Finance Committee at 5:30, followed by the board meeting. You need to adjourn, Ms. Ask for motion to adjourn.
Can I get a motion to adjourn?
Make a motion that we now adjourn.
Second.
Second.
Okay, the meeting is adjourned.
Thank you.
So we'll just come back.
Yeah, we'll do that later.